Okay, everyone. Our WebEx appears to be working, and we are streaming the WebEx to YouTube. So the only issue we have at this point is Harmony's not working, but Kathy is sending out an email to our distribution list to let those that think they should be looking at Harmony and waiting for the audio to start to instead go to YouTube. So I believe we're complying with the Open Meetings Act at this point in time. And so we're going to start back up for those of you that didn't know we tried to start before. Meeting is called to order again. We're going to start with request for bill introductions. And I had several from yesterday, people that showed up and we weren't able to meet yesterday, and I just told them that I would do it for them. And so I'm going to go over those again. We had 3 from Ed Klump with the Kansas Association of Chiefs of Police, the Kansas Sheriff's Association, and the Kansas Peace Officers Association. Those 3 are RS 0299, which has to do with surety bonds. RS 0300 has to do with protecting the addresses for our state and local corrections officers and administrative hearing officers. And then his third one, RS 0305, has to do with motor vehicle thefts and attempts to elude, which we had in this committee last year. Any objection to introducing those 3? Seeing none, they will be introduced. The next comes from the Attorney General's office. The first one is RS 0088. It has to do with the Crime Victims Compensation Board and them wanting to waive time limits in some situations to allow people to get compensation for mental health counseling services. The second one, RS 0360, was part of one we had last year, which moves the registration of charitable organizations from the Secretary of State's office to the Attorney General's office. And the third one is RS 0361, which would move the Safe at Home program from the Secretary of State's office to the Attorney General's office. Any questions or objections? Not, those will be admitted. I have one from the Kansas County and District Attorneys Association. RS 0363 has to do with speedy trial. Any questions? Any objections? Seeing none, it will be admitted. I know we have at least one committee member. We're going to give it a shot if we can hear from you. Representative Carmichael.
Thank you, Mr. Chairman. Can you hear me now?
I can hear you.
Very good. I do have one. Now I've got to find where it went on my computer. It's been an hour, you know. It was right here in front of me. Where is the dadgum thing? There it is, I think. Yes, Mr. Chairman, I would like to introduce on my own behalf 21 RS 0298, a constitutional amendment revising Article 3 relating to the judiciary, placing the Court of Appeals into the Kansas Constitution and changing the nomination and appointment process for Court of Appeals judges to match the process for Supreme Court justices.
Any questions? Any objection? It will be introduced. Anybody
Thank you,
else?
Mr. Chairman.
Thank you. Anyone else on the committee have? Yes, Representative Humphreys.
Thank you, Mr. Chairman. I'd like to ask to request introduction of RS 0120, and it's a tweak that we did last year to the adoption venue statutes. It passed through the House.
Very good. Questions?
Thank you.
Any objection? It will be admitted. Anyone else on the committee? Seeing none, anyone here with us today? Come on up on behalf of the Bar Association.
Hello. All right, let's try this again. Joe Molina with the Kansas Bar Association. We have 2 bills dealing with probate. The first bill is 21 RS 0327. It clarifies the transfer on debt deed, which is KSA 593504. The second is 21 RS 0233. It amends how we file wills. It is KSA 59618A.
You got any questions? Any objection? It will be introduced.
Thanks, Sally.
Thanks, Joe. Anyone else? This is just my reminder that I'll do for the first couple of weeks. If you've got bills that you're going to request, get those in, because I'm already scheduling out several weeks, and we know we've got some big topics to deal with in here. So the sooner we get them, the more likely they will get heard. We'll move on. We have one bill hearing today. I will open the hearing on House Bill 2048 and ask Natalie to give us a brief.
Thank you, Mr. Chairman. For the new members here, I wasn't able to introduce myself yesterday. I'm Natalie Scott. I work in the Office of Reviser of Statutes, and so our office provides bill drafting assistance for the committee. So if there are any bills or bill questions you have, feel free to let me know. Just wanted to do that for the new members. House Bill 2048 would extend certain provisions of the governmental response to the COVID-19 pandemic in Kansas. So essentially, we're extending some of the things that we did during the special session in House Bill 2016. Section 1 amends KSA 41-2653. That's the to-go alcohol sales provision. So subsection B authorizes the temporary sale of alcoholic liquor for consumption off premise through January 26th of 2021, and this bill would extend that to June 1st of 2021. Section 2 amends KSA 44705, which is an unemployment insurance statute. Subsection D to cap A 2Is suspends the waiting week period for new claims that are filed on and after April 5th through December 26th of 2020. So this bill would further extend that suspension through March 14th of 2021. Section 3 amends KSA 48924, which is the statute related to the governor's power to declare a state of disaster emergency. Subsection B5 currently provides that the state of disaster emergency may only be extended past September 15th if the governor applies to the State Finance Council for an extension for specified periods of up to 30 days at a time. And that can only happen while the legislature is not in session, and no extension can be granted after January 26th, 2021. So this bill would extend that provision, allowing State Finance Council extensions through June 1st, 2021. The bill also authorizes the governor to apply to the State Finance Council for that extension when the legislature is not in session or when they are adjourned for 3 or more days. Section 4 amends KSA 48924B, which was enacted during the 2020 special session to ratify and continue the state of disaster emergency declared by the governor from March 12th, 2020 through September 15th, 2020. This would extend that through March 5th of 2021. Sections 5 and 6 are companion amendments to KSA 48925. As you guys know, the changes that we made in House Bill 2016 to 48925 will expire and go back to the way that they were before House Bill 2016 on January 26th. And so this bill would extend the current law that's in 48925 through June 1st of 2021, and then it would revert it back at that time. So those two sections are read in tandem together. Section 7 amends KSA 48925A, which currently provides that the governor can order the closure or cessation of any business or commercial activity for 15 days, subject to extensions by the State Finance Council for 30 days each. Those provisions are set to expire on January 26th. So this bill amends the section to provide that during any state of disaster emergency related to COVID-19, the governor may not issue an order that substantially burdens or inhibits the gathering or movement of individuals or the operation of any religious, civic, business, or commercial activity, whether for profit or not for profit. And then these new provisions would expire June 1st, 2021. Section 8 amends KSA 48963, which authorizes the expanded use of telemedicine. This is extended through December 31st of 2021. Section 9 amends KSA 48965, which authorizes certain temporary emergency licenses related to the COVID-19 pandemic. And so those are also set to expire January 26th. This bill extends that until December 31st of 2021. Section 10 amends KSA 48966, which authorizes certain healthcare service providers to provide certain additional services through January 26th of 2021. And this bill would again extend that through December 31st of 2021. Section 11 amends KSA 605504, which is the business immunity from liability for COVID-19 claims. And right now, that section is set to expire on January 26th, and this bill would extend that through December 31st of 2021. And if passed, this bill would become effective on publication in the Register. So I can take any questions.
Questions for Natalie? Representative Heiberger?
Yeah.
Thank you, Mr. Chair. Natalie, can you go to section 7 in that first paragraph where the new added language prohibits the governor from substantially from limiting, burdening, or inhibiting gatherings of certain individuals. Can you give me an example of a gathering or movement that the governor would still be able to restrict under the language of the statute? Or is that a comfrey question? I'm having trouble thinking of it, something that the governor could prohibit under the language of the statute. It seems pretty broad.
Right. I mean, especially when you take into the account, you may not issue an order that substantially burdens the movement of individuals. I mean, that's pretty broad, even if you're just looking at that one item in the list. So, yeah, I think it would be hard to come up with something that she would be able to.
Okay.
Yeah.
Thank you.
Other questions? Representative Carmichael? I'm hoping you're muted because we don't hear you. Can you hear us, Representative Carmichael? Because we can't hear you. And I'm sure you just made really good remarks, but we missed them.
As a matter of fact, I bet I sound better this way, don't I? No?
Well,
Unmute. Can you hear me now?
now we can hear
Can
you.
you? Okay. I apologize. This is my first try with WebEx. Why can we use Zoom? Anyway, Ms. Scott, as I understand it, a number of the changes that we see here are actually just changes of date to continue provisions of the law that we have already enacted. Is that generally correct?
I think generally that is correct, yes.
Okay. But with respect to gubernatorial orders to limit gatherings, whatever a burden on business is and the like, those provisions are new provisions in the law rather than extensions of prior law. Is that correct?
So new, I mean, I'm just going to be very specific here. They are amendments to the current provisions, which provide that she's able to close business for 15 days and then she can go to the State Finance Council. So that portion is removed. And then we made some amendments to what types of orders that she may not issue. Yeah.
And Ms. Scott, I appreciate the distinction. Just for folks' reference, I think those changes are principally found at about pages 8, 9, and 10 of the bill if people want to look at them. But the change that is being made here as it relates to the governor's powers, separate and apart from extending dates, is that under the current law, and up until February 26th, the governor, with the consent of the Finance Council, can enter orders or proclamations that do have an impact on gatherings and could even impact businesses. Is that generally correct?
Yes, and actually, I think if I heard you correctly, you said the governor, like with the State Finance Council, could do those things.
Yes.
Right now, actually, the governor can do it on her own for up to 15 days because she has not used those 15 days that were allowed to her under these, the current law.
And I
then after
appreciate
those
this.
15 days, she would have to go to the State Finance Council.
So so are you telling us that the 15-day provision that is in the current law has not been used by the governor as of yet, and that whatever gubernatorial proclamations we've seen have been pursuant to other portions of the law?
That is correct, yeah.
Okay. But now what is going to happen if this bill becomes law and effective, presumably on the expiration of the current law, January 26th, I think, is that the governor cannot issue any type of an order burdening business gatherings. I can't remember the magic language, but that's even with or without the Finance Council's consent, or can the governor still go ahead and issue orders in dire circumstances with the Finance Council's consent?
As drafted, there would be no way for her to go to the State Finance Council to get approval to do that. So she would not be able to issue any order that substantially burdens, inhibits the movement of people. And then subsection B provides that any order that's issued that violates subsection A would be null and void.
So this bill is substantively different than the current law, at least to the extent, and there's other matters too, but at least to the extent that this bill says the governor, not even with the consent and even unanimous or consent of 6 legislative members of the Finance Council, the governor can't issue any type of restrictions, at least as described in the bill, whereas today she could do that.
Correct.
Can anybody, even if the Finance Council is 100% in agreement that this is an absolute disaster, we've got to do something right now before hundreds of thousands of Kansans die, can the governor issue that type of an order with the unanimous consent of the Finance Council, or is it just all over now? Can't do it at all?
So the governor still maintains her authority under 48.925 to issue, those variety of orders while we are under a state of disaster emergency. But any order that would substantially burden the movement of people would not be allowed, no matter how the State Finance Council felt about it.
All right.
Take legislative action or something like that.
And Ms. Scott, I apologize for my being inarticulate here. I wasn't a member of the special committee this summer during the testimony. My other area of questions concerns immunity for businesses. Are we doing anything in this bill other than extending the expiration date on the already existent immunities contained in the present law?
No, this bill, the only thing this bill does right now, the only section in the business immunity provisions that is set to expire is this section that's in the bill right now. And so it's just pushing that expiration back from January 26th to December 31st.
The specific reason that I ask is I've been contacted, as I'm sure many of us have, by a number of organizations who are very concerned, wanting immunity, for example, nursing homes and the like, and other organizations who have good ideas about other forms of immunity they would like. But at this point, the scope of the immunity remains the same as the present law. We're not adding any new businesses to the scope, nor are we taking away existing immunity. Would that be correct?
So I just want to make sure for clarity, this section of law applies to business immunity. There are different sections of law that passed in House Bill 2016 related to adult care facilities and healthcare provider immunity. Those have their own retroactivity provisions. They go retroactive back to March 12th through the state of disaster emergency declared by the governor. And those are not included here. This is just the business provision. And so the business provision was the only one in the bill that was set to expire on January 26th. And so the scope of the immunity here in this business provision is not being impacted. It's just being extended.
I appreciate the distinction. Mr. Chairman, I appreciate your indulgence with me. There are some technical inconsistencies that I've seen in this bill, but I think we can talk about those together without taking the committee's time at this moment. Thank you.
Other questions for Natalie? Representative Humphreys, then Sampson.
Thank you, Mr. Chairman. So Natalie, I just wanted to make sure I understand Section 3. And so my question is, it extends, this bill extends the provision until June 1st, 2021. What provision is it extending exactly? Because then you say the bill also authorizes the governor to apply to the State Finance Council. So if we're in session, what is it extending until June 1st?
So the state of disaster emergency declaration is, under this bill, would expire on March 5th. So what Section 3 does, the changes in Section 3 are to keep the current law where she can go make application to the State Finance Council for an extension of the disaster emergency.
Even if we're in session?
No, the not in session is still there, but we did add or is adjourned during session for 3 or more days, because there was a question as to April break. Are you in session or are you not in session? So we just wanted to clarify that. But so anytime from when the state of disaster emergency expires, which in this bill would be June 5th through June 1st, she would, or March 5th through June 1st, she would be able to go to the State Finance Council and request an extension.
Okay, so
If you're
after
not in session.
March 5th, but we're in session.
If you're in session, she cannot go to the State Finance Council and ask.
So how does she extend it then?
You have to extend it.
If we don't pass this to extend it to June 1st, then after March 1st, she would have to come to the legislature to extend it.
Yeah, so
Or before it expired.
right now, the disaster declaration expires on January 26th. This bill contains a provision to extend that to March 5th. Now that you guys are in session,
Okay.
the ability to extend the disaster declaration is on you guys until
Very
you're
good.
not in session anymore.
Okay, and can you tell me, the State Finance Council, is it as it has been in the past, is it the same, the voting, as far as when she wants to extend it, it's a majority of the State Finance Council?
We don't make any changes to
Okay.
those provisions. Obviously, the membership of the State Finance Council changed because, of how
Leadership.
that's fixed, but it still requires, the requirement that it's a majority of the legislative members remains the same.
Thank you. Thanks. Thank you, Mr. Chairman.
We have a question from Representative Curtis, who can't figure out how to raise her hand. It says, are the executive order protections for evictions continued under this bill?
So the current eviction protections are done by an executive order. And the reason that Governor Kelly has the ability to issue that executive order is because of the disaster declaration. So we're not doing anything specific to the eviction things. If this disaster is extended, I suspect that she would issue a new executive order covering the evictions. But we would have to ask her legal counsel about that. It's not covered in the bill.
Representative Sampson.
Thank you, Mr. Chairman. Natalie, just to make sure I understood this correctly, I think I did, but this is essentially a continuation, if you will, of House Bill 2016, which we considered during the special session, correct?
Essentially. There are some changes, yeah.
Gotcha.
Essentially.
And the reason that is helpful to me is if I recall correctly when we debated that is, and I'm looking at that bill in front of me at the moment, but it strikes me that if I recall correctly, that was an agreement in principle, or at least furthered by our Senate Vice President, our Speaker Pro Tem, and then the Governor's Office. And essentially, I'm seeing that it passed in very large numbers and it was approved by the Governor, but it would have some changes which we'll flesh out as we go along.
Yeah, the principal changes are to the business closure section.
Excellent. I do have one question about what the governor's position is on this one. I don't see her listed anywhere in there, but that's probably not a question for you, I suspect.
Absolutely not a question for me. Yes, thank you.
Well, and not what her position was, but whether she had, if she was.
Oh, yeah.
That makes sense, Mr.
Yeah.
Chairman, if she was going to have somebody here to tell us whether she's behind this, opposed to it, et cetera. So,
Just to clarify, we came up with that business language from the governor's proclamation that we're still operating under. In there, she said, no executive orders issued under the authority premised on this proclamation will be used to restrict businesses from operating or to restrict the movement or gathering of individuals. And so when Natalie and I were cleaning this thing up, we used the governor's, pretty much the governor's language instead of what we had in 2016. So that's where we came up with that.
Mr. Chairman, Carmichael, I'd like to be recognized at your convenience.
Sure.
Let me
If
just point
that-
out one more thing related to that real quick. I would note that it's also substantially similar to the prohibition on business closures that was in effect for prior to September 15th in KSA 48-925. That subsection E expired on September 15th, but this language is similar to that as well.
thank you, Mr. Chairman. And I think that in the essence of time, I was just trying to make sure, to the extent we've heard testimony in the past or positions, it may be very similar to what we heard on HB 2016. Thank you, Mr. Chairman.
Representative Burris.
Thank you, Mr. Chairman. I had a question about Section 6 of this legislation. Specifically, it looks to me like Section 6 would operate to, I guess, strike a number of what could be called enhanced protections or checks and balances that were added to 48-925 by HB 2016. In other words, those enhanced protections or checks and balances would terminate as of, I guess, June 1st. Is that correct? Under this legislation?
Yes, so Section 6 and 7 are a little bit complicated, but you will remember that the changes that you're referring to in KSA 48-925 that were put in place in House Bill 2016 are currently set to expire on January 26th. And so essentially what Section 6 and 7 operate together to do is extend what is currently in 48-925, what you guys passed in House Bill 2016, through June 1st of 2021. And then it will revert back to the way that statute looked before House Bill 2016 was ever passed.
Thank you, Mr. Chairman.
We have Representative Owens, then Carmichael. So Owens first.
Thank you very much, Mr. Chairman. I wanted to go back. We were talking a little bit earlier about the governor's authority to restrict movement, things like that. That would have been, looks like page 9, line 37. My understanding, this says the provisions of this subsection shall expire September 15, 2020. Well, that's in the past. So is this?
Yeah. So that's kind of what I was talking about, how these sections kind of have to be read together. It's a little bit confusing. So we left that in there, even though it is dead law, because that is what, if you were to open a statute book today and look at KSA 48-925, that's what you're going to see. So the purpose of that section is to extend all of those provisions through June 1st. And so it would have been technically, technical cleanup like we do to kind of delete that out of there. But just to preserve everything for right now, we just put that back in there, even though you're absolutely right. It will be dead law. It won't apply.
One other question. Are we not getting the legislative briefs this go around? Normally, there's kind of a bit of a brief ahead of time about the bill.
Yeah.
Revisers.
I think you do have
In there. It's in that.
in the testimony.
I may not have gotten that far to.
Yeah.
It might be alphabetically. I don't know. Is it Reviser or Natalie or? Oh, okay.
Okay. All right. Thank you very much. Thank you, Mr. Chairman. Thank you, Natalie.
Representative Carmichael.
Thank you, Mr. Chairman. I just want to note, and I know, Mr. Chairman, you're doing your best to make this work. The governor's office did not see the language in this bill. So far as I know, at least the governor's general counsel did not see it until late yesterday afternoon. I received an email just before we sat down at the hearing from the general counsel suggesting that the governor is not necessarily in agreement with this language that we see at pages 8, 9, and 10 that you and Ms. Scott lifted from, I guess, a governor's proclamation, which was made in the face of the Finance Council threatening not to extend a governor's order. So I don't mean to cast aspersions on anyone, but I don't think it would be fair to assume that the governor agrees with this new law that is contained at pages 8, 9, and 10. And I'm doing my best to get a clarification even as we speak. Thank you.
Thank you, Representative Carmichael. Please pass on to them that they're welcome to reach out to me and, of course, could have shown up today to testify as well. Any further questions?
Believe me, Mr. Chairman, I've done those two things repeatedly. Thank you.
Thank you. I appreciate it. Okay. Thank you, Natalie. We will now move on to our conferees. I certainly want you to say anything you want to say. Try to restrict your comments if you can. We're almost at 5 and we've barely begun. So if someone's already said something you've already said, feel free to say ditto, or, you know, I like what Eric said. Not that anyone will say that, but if someone agrees with Eric, feel free to say that. And also, so you know, I've yet to schedule it, but we are going to have additional opportunities to talk about KEMA and what the long-term changes may or may not be. So we will start proponents, and first one up is Audrey Dunkel.
All right, Mr. Chairman, the pressure of being first. Again, I'm Audrey Dunkel. I am the Vice President of Government Relations for the Kansas Hospital Association. Thank you for having us here today to speak on behalf of our membership. I will make this very brief. Thank you for passing House Bill 2016 last year. It has been very, very important for our hospitals moving forward. Amongst the things we would like to see continued are the telemedicine flexibilities, the flexibilities in licensed bed limits and usage of space, the flexibilities in licensures to address staffing, and the liability protections continuing, of course, are all important. 2 of those things you have in this bill, 2 of those things continue from the prior bill. Given the amount of time, we are obviously in support of 2048. We do know that the Board of Healing Arts has some adjustments to the licensure language, and we've been working with them to make that work moving forward. Thank you.
Very good. Thank you. Next we have, or in committee, we'll do questions at the end of all the conferees, so keep a list. Next we have Mike O'Neill.
Feel like a member of Congress now with my struggles with my mask. Mike O'Neill here today representing the Kansas Policy Institute and also the Kansas Justice Institute. The testimony that we have really addresses more the deep dive, and so our testimony is really based on the presumption that once we get through this extension, that buys you a little bit more time to look at the act, that you'll look at some of the things that we've suggested here. The one thing that we would suggest maybe in the interim is addressing, and I think I heard the reviser state that you've addressed the issue of the definition of session. Historically, session has more or less been related to the session that begins the second Monday in January and ends at sine die. And we know that COVID has actually created situations where you're actually adjourned for more than 3 days or 2 days, and you need to be able to address that. Sounds like that was already addressed. So we certainly support what you're doing here. Our particular interest, particularly representing the Kansas Justice Institute, is primarily the litigation that has taken place in the state related to COVID, and the litigation that is being addressed countrywide has to do with the limitation of gatherings. And I appreciate the fact that you have done a minor tweak to that language, because that's what has been generating the most litigation. We want to get to a place where orders are based upon facts and causation, and not a situation where you may have an outbreak in one isolated place, and then by implication, there's an assumption that every other similarly licensed place is equally bad. And that's where you're going to invite litigation. So anyway, we look forward to partnering with you to provide any research and background and consulting on as you move forward with the Emergency Management Act, knowing that you're doing, hopefully you'll go more than just the Emergency Management Act, because there's a lot of local statutes that affect the locals that I think ought to be looked at as well, because they haven't been looked at in years and years and years. They're pretty broad ranging. Things like all known measures lacks any sort of definition. And so that's all taken care of in my testimony, and I'll just leave it there, and thank you for your time.
Thank you. Next, we have Eric Stafford.
Thank you, Mr. Chairman and members of the committee. Good afternoon. My name is Eric Stafford, Vice President of Government Affairs with the Kansas Chamber, here to testify in support of this legislation and extending these provisions, specifically speaking today about the business liability pieces. We worked diligently last summer to get some limited liability coverage. Thank you to the legislature for passing that and for the governor for signing it. As that language just dealt with just general liability as well as product liability. Going through the bill today, I'm seeing a paragraph from the section that was in House Bill 2016, just dealing with the civil action for COVID claim if such person was acting pursuant to and in substantial compliance with public health directives applicable to the activity. And that got me thinking and said, well, wait a second, where's the product liability section? And sitting here this afternoon, just noticing that that section's not in there, we would just ask if we could get that included. That would be fantastic. The not looking for any different language than what passed this summer, but I think those were the two key provisions that were included that we would like to have added or included in this bill as well, as we look toward a more long-term KEMA fix. So with that, be happy to answer any questions at the appropriate time. Thank you.
Thank you. Next I show we have Ron Hine on WebEx, but I don't see him on my screen. Oh,
Mr. Chairman, hopefully I meet the testimony germaneness standards. My name is Derek Hine. I'm testifying in place of Ron Hine today. I'm representing the Certified Registered Nurse Anesthetist Association, the Kansas Association of Nurse Anesthetists. I will be brief, and this is an issue that we testified on in Senate Judiciary as well. It has recently come to our attention that House Bill 2016 may have inadvertently authorized providers which are not licensed, healthcare providers which are not licensed in the state of Kansas to practice in the state of Kansas. We don't believe it was the legislature's intent in House Bill 2016 to circumvent the legislative process by which healthcare providers are authorized. We understand this bill was passed under extraordinary circumstances. Senate Judiciary earlier today, rather than amending their language, put some legislative intent language in the minutes. In Ron Hine's testimony, that is included. You can take a look at that, and we would suggest that you include similar language in your minutes when you pass this bill out. I'd be happy to stand for questions.
thank you. Next, we have Daniel Murray.
Thank you, Mr. Chairman, members of the committee. My name is Dan Murray. I'm the Kansas State Director for the National Federation of Independent Business. NFIB Kansas represents about 4,000 small business owners from across the state. And as Mr. Stafford mentioned, we stand here today with the business community expressing appreciation for the bipartisan effort last year to get the business and product liability provisions passed in House Bill 2016, and we support that extension moving forward. Small business owners, small business firms represent over 99% of employers in Kansas, with about 51% of employees in Kansas. And so we look forward to having a seat at the table as you explore ways to make KEMA work moving forward. With that, Mr. Chairman, I would stay for questions and do appreciate the opportunity to speak.
Great, thank you. Next, Nicole Milo, I believe, if unless I butchered my first name of the session. Nicole is on WebEx.
Yes, thank you, Chairman. And thank you to the rest of the members of the Judiciary Committee for allowing me to speak today. My name is Nicole Milo. I'm the System Director for Government and Community Affairs for Centura Health. We are a not-for-profit health system that has 17 hospitals and 15 affiliated hospitals in Colorado and Kansas. So from a provider perspective, we are in full support of extending the provisions of the House Bill 2016 that's set to expire later this month. So I just wanted to make the committee aware of how important the provisions in this bill are to clinicians coming into Kansas. So throughout the COVID-19 crisis, we have relied on a shifting of resources that exist inside of our system to meet the needs of each community in which we serve. So as you're aware, in the spring, PPE was one of our greatest needs, and we were able to shift resources there. But now we are plagued with the limited resource in critical staffing that is so necessary in treating this pandemic and working on the front lines. So the provisions of House Bill 2016 have allowed us to flex visiting Centura physicians, advanced practice practitioners, nurses, and therapists from Colorado into Kansas to help us during these high surge times. And so I want to give this committee an idea of what this really means. So out of the last 90 days in St. Catherine Hospital, which is one of our hospitals, over 72 of those days we have been short-staffed. And what that equates to for this committee is in high surge times, that was between 40 and 60 open positions that we had at any given time. So the ability for our system to flex resources on demand to meet the needs of the residents of Kansas has been critically important to our operations. We would also like to recognize the importance of the meatpacking industry in the communities in which we serve. And while there has been outbreaks that typically occur in what we describe as clusters, we always want to ensure that we are ready to meet the needs and the healthcare challenges that have presented through the COVID-19 pandemic. So while the vaccine that is beginning to roll out in our communities is giving our providers hope, we still are grappling with extenuating circumstances for our providers, whether it is them getting ill or exposed to the virus themselves, them being challenged by homeschooling or childcare issues, or even the fatigue that continues to plague the front lines. We really are relying on these provisions to help us continue to meet the needs for the residents of Kansas, as we expect vaccine rollout for us to extend well beyond fall of 2021. So thank you so much for the opportunity to testify today, and I look forward to any questions that anyone may have.
Thank you. Next, we have Rachelle Colombo.
Thank you, Mr. Chairman and members of the committee. I'm Rachelle Colombo. I'm the Executive Director of the Kansas Medical Society. I appreciate the opportunity to appear before you today and provide comment on House Bill 2048. I will try to be as brief as possible. It is our understanding that this is in large part an extenuation of the provisions that were provided in House Bill 2016. Among those were liability immunity protections for healthcare providers. Those are not contemplated in this underlying bill because they were not tied to a calendar date. Those were tied to the governor's emergency declaration, and this bill does not contemplate restricting the power of the governor to declare an emergency, but those provisions which are considered under that emergency declaration. So there's two things I would like to say today. The first is, again, thank you very much for the provisions that were included in House Bill 2016. We worked very hard with members of the legislature, the administration, and the business community to make sure that healthcare providers were able to continue to provide access to care for both patients with COVID and without an increased level of liability as a result of this unpredictable time. And so we very much appreciate those things which were included in House Bill 2016 and understand that those will continue on. However, we also support the business liability protections that are included in House Bill 2048. And this is really the first opportunity that we've had to comment on those provisions as a whole as they are considered in moving forward. And while we support those things that are considered for the business community, there are some provisions which relate to healthcare providers, which actually I think the intent of the legislature was clearly to provide the utmost access for all patients in Kansas as a result of the pandemic. But unfortunately, some of the provisions that were included do undermine patient safety and are inconsistent with the current law. And we would ask that at the time in which we understand the importance of extending the emergency management provisions, and we support that, but we would ask that if such an opportunity presents to look at those underlying policies that are extended in this, that you all consider whether or not they are necessary and whether they are consistent with protecting public health. The Board of Healing Arts will testify later this afternoon about those things which are not consistent relating to licensure and regulatory authority, which are really designed only to provide public safety. And there are other provisions which already provide those necessary safeguards. And so we would suggest that there maybe needs to be a bit of work done to not create inconsistencies which create unintended consequences in the future. But in general, we support your efforts and appreciate all that you've done through House Bill 2016, as well as being here today to support what is necessary for patients and individuals across Kansas, whether they're dealing with COVID or not. And I'd be happy to stand for questions. Thank you.
Thank you. John Jinks. John appears to be written. Amanda Stanley, while she's on the list to be a proponent, well, she is a proponent, but she's not going to appear. She's going to allow her written testimony. Kevin Walker. Kevin's going to be written as well, and I don't see Tuck Duncan. Is Tuck here? No Tuck. Okay, so written proponents, we have Scott. Are you? Yeah, Scott, come on up. So Scott Schneider's next. He's listed under written, but he's here, so we're going to hear from him.
Thank you, Chair, members of the committee. I'm Scott Schneider. I work for Hinkle Law Firm, representing the Kansas Restaurant and Hospitality Association. We've had one heck of a year, as you can imagine. Three things came to mind this year as I was reflecting a little bit about it. First is how fragile our laws actually are. You know, we have been chasing governments around trying to educate them on things that they can do, things that we think are within our rights to do. But I think the sturdiness of our laws really we need to take a deep dive on this, because it's exposed, I think, some cracks. The second thing that I thought about was how disproportionate many of these, whether they're orders by the county, the city, the state, pick one. I'm not trying to pick on any unit of government. They're our friends, they're our neighbors, but how disproportionately many of these impacted the hourly worker, the working poor, people who have the least ability to recover from some of these financial losses. And finally, I had this crazy thought in about October that, man, I wish the legislature was year-round, because there is no way else to go solve these but for legislative actions. And then I kind of woke up and said, oh, that's stupid. We don't want that. But I think when it comes to curbside delivery or curbside and carry out of alcohol is really why I'm here. But we're here for, so many more reasons. This one piece is probably the only positive thing that's happened to the restaurant industry that puts an actual dollar in somebody's pocket. The rest is going the other way. Every day somebody's restaurant's open, they're losing money until this thing kind of subsides. But the consumer's behavior has changed, and I think to the extent that we can adapt some of these laws, whether they're temporary, but we'll be working on this on a permanent solution also. I think it's incumbent upon us to try to do everything we can to reflect that our laws or our customers' behaviors are changed, and our laws support that. So I'll be here if you have any other questions. Thank you.
Thank you. So on the list of written proponents, I have the Kansas Advanced Practice Nurses Association, the National Council of the State Boards of Nursing, and the Kansas Association of Counties. Anyone else as a proponent? Okay, if not, now's the time for questions, and I have Representative Carmichael first on the list.
Thank you, Mr. Chairman. I Hope you can hear me now, as they say. Hopefully. Okay, I'm going to assume that you can hear me. I note in Mr. Jink's testimony that he tells us that while we agree that individuals with legitimate grievances should have a reasonable course for justice against a company that acted negligently and knowingly put the health of workers at risk, we believe that misguided and frivolous litigation cannot only prevent businesses from reopening, but can also force scores of businesses to close their doors and cause thousands of workers to become jobless. So I don't know if my question is specifically for Mr. Jinks, but it can be for any of the panelists today. Other than the 2 or 3 lawsuits that have been brought against nursing homes where upwards of 20 people have died, is anyone here aware of any other frivolous, or even for that matter, unfrivolous lawsuits that have been filed against Kansas businesses on account of COVID?
So Representative Carmichael, Mr. Jinks is not here today. Does anyone else want to attempt to answer that question? I'm not seeing any takers, Representative Carmichael.
Well, I appreciate that, because my presumption and my best information is the answer is 0. Thank you, Mr. Chairman.
Any other questions for the proponents? Representative Samsel?
Thank you, Mr. Chairman. I may start with Mr. Stafford, if I may, but I'll also open it up to anybody depending on the answer. But I understand there's a little bit of squabble over the date of when this may be getting extended to, as far as June 1st, 2021. I also understand, and please correct me if I'm wrong, but it looks like we have 7 working days to get this to the governor's office. And I was not meaning to throw shade at the governor's office earlier. If they have a position on this, I would love to know what it is, so we can certainly incorporate that as we work. But in order to get something passed into law before this expires on January 26th, it looks like, I'm curious if from the business community, and then I may also ask briefly, because I work very closely with a lot of our restaurants and hospitality industries, Mr. Schneider, if I may, but does extending this to June 1st, and this I know is a very broad question right now, but does that give certainty things in the business world that helps you guys and your workers? Or if that were to be reduced to, let's say, March or April or something else like that, and then we've got to hash this stuff out. I realize there's many battles in the weeds to do after we get this done and temporary in place, but if that question makes sense, I wondered if the June 1st date is good, or March, February, April, if you would, please.
The more the better, but to make sure that we don't bump up against the January 26th is the goal, and we're going to work as hard as we can to pass a subsequent bill to make sure we make these provisions permanent also. But the more certainty that we can have, the more product people can actually order and not have stranded costs and just paper products. So there's a lot that goes into, are we going to serve on the 26th or are we not? So generally, I would just say that the more the better, but hopefully we can fix it even before then. So
thank you. And very briefly, Mr. Stafford, if you had any different opinion, not to put you on the spot, or if anybody else disagrees with the June 1st date and thinks it should be earlier, I would appreciate knowing that.
The implementation day, sorry, I had to run downstairs real quick, so I missed what was going on.
Sure, I was trying to understand, and so without repeating that for everybody else's time, but it looks like this was a continuation until June 1st because we've got the pressing January 26th deadline.
Right.
So it looks like we've got only 7 working days to get something to the governor's office and hopefully approved. So I was curious if the June 1, like my understanding of business is certainty helps you guys in the business world. And June 1st seems to strike me as helping that as opposed to something in February or March or April or May.
Yeah, I would agree with Scott. The longer duration of protection we could get, the better. June's definitely better than March 31, which I think is the Senate version, but March is better than January 26th. So I think whatever you guys can agree to helps, under the assumption that this is essentially more of a short-term fix as we look at the bigger KEMA type reforms. If that continues to be, if liability protection continues to be a part of that discussion, we'd greatly appreciate that. But yeah, I think certainty is key, and the longer the extension, the more certainty you guys are providing the business community.
Thank you, Mr. Stafford and Mr. Schneider, and thank you, Mr. Chairman.
Before you step away, take a look at House Bill 2016. Natalie and I are both of the position that the product liability piece does not sunset, so we don't need to extend it. If a product was designed, produced, manufactured in response to COVID, I think you're good. It's similar to the healthcare piece. So you don't have to look at it right now.
Yeah, I appreciate that
Next day or so.
explanation, which is why I'm not an attorney, but I do sleep on a comfortable bed. So thank you.
Further questions? Okay, seeing none, we will move on to our neutral conferee, Tucker Polling.
Mr. Chair, members of the committee, my name is Tucker Polling. I'm the acting executive director of the Kansas State Board of Healing Arts. We're here to provide neutral testimony because we understand that, as have been pointed out by other conferees, there is a lot in this bill that's very important that needs to get done. Just to clarify, because I find a lot of people don't know a lot about who we are, the Board of Healing Arts is composed of 15 members, 12 of whom are healthcare providers. We license over 32,000 healthcare providers in the state of Kansas. And as a housekeeping matter, I presented some testimony initially that referenced the HB 2016 subsections. I did send updated testimony yesterday. Hopefully you got that. That has the corrected subsections. But if you're looking at some testimony from me that references new section 23, I'm referring to section 10 of this bill. You have my written testimony, and I want to respect everyone's time, so I won't repeat those things. But I do want to focus on a single issue that my board has the greatest concern about in regard to continuing this out for any significant amount of time. And that's the one that deals most directly with public safety. That is the first and last sentence of subsection H of section 10. What that does is it allows anyone who is from out of state, an out-of-state healthcare licensee, to come practice in Kansas without any of the same oversight that all other healthcare providers in Kansas have. It's a jurisdictional problem that prevents us from enforcing the same rules on those healthcare providers as Kansas healthcare providers have to follow. So, you know, the problem with those two sentences is you have the rules that all Kansas healthcare providers have to follow on one hand. They follow those rules. They've always had to follow those public safety rules. But then you've created this class of out-of-state providers who we don't have any jurisdiction over, and they don't have to follow the same rules that Kansas providers have to follow. I agree with one of the prior conferees who, I think it was Mr. Hine, who suggested that there were aspects, that section, that were perhaps an oversight by many in the legislature. I tend to agree with that. I don't think it was appreciated exactly what Section H does. And if you delete those two sentences, the first and last sentence of Section 10, you still keep intact the policy pieces that you've heard a lot of support about today. In the healthcare sector, what I'm referring to is the telemedicine piece, expanding telemedicine, and the emergency temporary licensure piece. So sections 8 and 9 of this bill preserve those pieces. So people from out of state can still come here and practice to deal with the capacity issues that the individual from Centura was referencing under section 9. The difference is we then have jurisdiction over them, so we can make them just follow the same rules that all Kansas healthcare providers follow. So I think that you can delete you can delete those two sentences that I've referenced without harming the issues that have been beneficial to the healthcare community in terms of increasing capacity. Because again, that emergency temporary licensure process, if you have a clean license from out of state, you can practice here. and we turn those around real fast. That stays intact. There was a reference to the statement of intent from the Senate committee this morning. I appreciate and respect the motivation to make things better in that statement of intent. Respectfully, I do not believe that statement of intent has any legal effect. I do not believe it addresses the issue I've just described in regard to Section 10. The language in the first and last sentence of Section 10 is not ambiguous. It is very clear. And in a person in my role, we have to follow the law, not what we think that the legislature really meant or what we wish they would have meant. That law is clear. And so I cannot go against that based on a statement of intent. It would have to be, in my view, an amendment to the statute. So I appreciate the desire, the motivation, but I do not think that helps the issue. The representative from KHA also referenced another issue to help with more quickly getting those out-of-state providers licensed under the temporary emergency licensure process in Section 10, adding a sentence to, in Section 9, the emergency temporary licensure section, adding a sentence to that section stating that applicants who have a temporary emergency license shall not be required to pay the surcharge required under 403401. That's the fund statute. That would assist us in getting those issued even faster. So that, I believe, was what was referenced by the KHA representative. So that would be another change we'd be supportive of. And I'll stand for questions at the appropriate time.
Very good. And this WebEx is going to give Representative Carmichael first in line every time because he's able to tell me he has a question without anyone else having the chance to raise their hand. So Representative Carmichael, you're up.
Mr. Chairman, if you wish, I will be happy to defer until later in the questioning so as to give others the first bite at the apple.
Looking around, I think you're the only one. So.
Oh, how disappointing.
Maybe not, but go ahead.
Mr. Poling, I appreciate the helpful testimony that you've provided us over the past few days in advance. My first question for you was going to relate to your opinion regarding the efficacy of a statement of intent, such as was placed in apparently a bill by the Senate today. But I think you and I are in agreement that the law in Kansas says one only looks to intent if and when there is the word escapes me now, but
ambiguity.
An ambiguity in the black letter law. And I think what you're telling us as the administrator, if you will, of these licensure laws, that there's no ambiguity, and so hence you can't rely upon a statement of intent. There has to be a change in the black letter. Is that correct?
That's correct.
Okay. Now, as far as the necessary change in the black letter, I think you're talking about at page 14 of the bill in Section 10.
Well, the copy that I have,
you may be working with a reviser's draft.
Section 10 does begin on page 14, but the specific subsection I'm talking about, perhaps I wasn't clear enough, is subsection H, which is on page 16. My copy indicates it starts on line 15.
I'll tell you what, rather than working this right now, and I'm not sure when the chairman intends to work this bill, but I know it will be soon, would you mind later this evening or first thing in the morning, give me a call so that we can make sure that we've tried to prepare a balloon amendment that takes into account the board's concerns on all of these topics?
Absolutely, yes.
And then, Mr. Chairman, the other question, I know it may be somewhat out of order, but if we did what Mr. Poling suggests, would that satisfy, I believe it was Mr. Hines' concerns as well? Or do we need to do something different to take care of his clients if he's still available?
Representative Carmichael, the amendment would be preferred, I think is my short answer.
The amendment, what amendment, sir?
The amendment that Mr. Poling has suggested would be our preference.
All right, so from your perspective, if we do what Mr. Poling suggests, you think that that would probably resolve the concerns on the part of your clients as well?
Yes, sir.
Excellent. Thank you, Mr. Chair. Appreciate your courtesy.
Representative Samsel.
Thank you, Mr. Chairman. Just one question, please. Very similar to what I asked earlier. And again, I may be wrong, but it sounds like there may be some battle brewing on June 1st or some other date with our friends and colleagues over on the other side of the Capitol building. June 1st, you guys like that date? Don't like it? March, April, next year?
Well, we think that the changes I've highlighted can be handled without getting into the date debate. That said, if the changes that I've highlighted are not made, we strongly feel that the shorter the better on an extension, at least as to what I've referenced, Section 10. But again, we think that the revision that I have suggested could be achieved without harming the policy goals.
And if we make those changes, then June 1st would probably be a good preferred date for you guys.
If those changes were made, we would leave it to your discretion on the date.
Thank you. Thank you, Mr. Chairman.
Any other questions? So my suggestion, and Representative Carmichael already brought that up, is that we do need to work this bill fairly quickly. So if those interested parties, and I know a number of you are here today, if you can get together with Representative Carmichael or me or whoever and the revisor's office, and we can get some language, because the discussions I've heard, I think we can get there. So let's figure out what that language looks like and pull it off so we can be ready when we work it. Thank you. And we have one opponent. I believe Nick is on WebEx. Nick Reinecker. Are you out there, Nick? You're up.
Good evening, Mr. Chairman and committee. Thank you for allowing me to speak. My name is Nick Reinecker. Can you give me just a ballpark figure of time that I have?
Very little, like 3-4 minutes.
Okay. Well, thank you, sir. Regardless of this bill, the Emergency Management Act obviously needs some attention. However, I want to, concentrate on the how we got here. When on March 7th, when the KDHE confirmed the first case of novel coronavirus, my question would be, what was the PCR rate as far as the cycle thresholds to kind of get that tree started? And if it's not a good proclamation due to the fact that every year we do not have a influenza disaster emergency or a MERS or a MARS or an H1N1 disaster declaration, why did we do it this time? So, with 3 minutes, I guess I can't really go into a lot of stuff on my why I'm an opponent, but I can know that as far as how we're going and changing definitions and goalposts and just keeping a lot of confusion and delay, it's not really a good situation. I did want to say on the first, being an opponent, I'm really an opponent to having the declaration as it is. And so with that, the first fatality from the coronavirus was a 61-year-old man who had abdominal tumors and chronic liver disease as underlying conditions. I know when my father passed away, he passed away from, it was pneumonia listed as the first, primary cause of death, but he had underlying conditions of chronic renal failure and diabetes. And so as we go along here, I guess my biggest question is, what besides the legislature's ability to rescind the governor's order, what are the criteria for the state of emergency disaster declaration to be over. And then just going through the bill really quickly, there was a concern that I had on back in the 9, 10, and 11. There was language that had stripped the putting in, well, let me just find it real quick. I'm sorry. On page 11, line 36 through 39, eliminating some sort of conformity with the Constitution and the Bill of Rights. And maybe that's what Natalie was talking about, how those sections were kind of intertwined. I don't know. But anyway, my biggest thing is let's err on the side of individual liberty. People are missing out on hugs and closeness and human contact, and we got to look at the unintended consequences of mental health and children losing some of their education opportunities and everything like that. But I've talked more than I should. I appreciate it. Thank you for all the work that you do, and I hope we can do that deeper dive.
Nick, any questions? Okay, I'm going to close the hearing on House Bill 2048. Committee, I have intended and I would really like to be able to work this tomorrow, but I know we may need some time. So I'm still going to have it on the agenda as something we intend to do tomorrow. Now, I will announce at some point tomorrow if that changes. Hopefully we can get some language agreed to from the Board of Healing Arts and what the other parties would agree to. Hopefully we have a chance that Representative Carmichael can hear back from the governor's office and see where we're at there. So I will let you know if we're not meeting tomorrow, but I would like to meet tomorrow and try to work this bill, because as Representative Samsel pointed out, every time I look at the calendar, I get a little bit more and more nervous that January 26th, while it is 7 business days away, this is not a bill that we can just go to conference on. We don't have shells, and so it's going to have to pass both chambers, and the governor's going to need some time to think about it and decide if she wants to sign it or not, and if she doesn't, then how do we have time to get back through this process again? So we need to move this as quickly as we can, and tomorrow would be as soon as we could do that. So I'll let you know if we're not going to meet, but everybody should be working with the intent that we're going to try to work this tomorrow. Representative Hoheisel.
Thank you, Mr. Chair. If we are not able to get this out tomorrow, is there a chance we do it Friday?
There is a chance. We are calling for the chair on Friday.
Okay.
So I'll keep you all posted. Representative Samsel?
Thank you, Mr. Chairman. My question is procedural. I understand with WebEx, we can participate remotely, but cannot vote.
Correct. That's. I'm glad we bring that up. We've not gotten to adopting our committee rules yet, which if we do meet tomorrow, we'll try to do that tomorrow, and we'll finish up the introductions because we didn't have time for staff and those that could not get in yesterday. So we'll do that tomorrow as well. But one of the committee rules that I'm proposing is that you are welcome to participate in our committee meetings wherever you would like, but on days that we're going to work bills and vote on them, that you need to at least be in the Capitol. So you can WebEx as long as you're in the Capitol building. That just to be safe, we had the Attorney General opinion on it, that final action certainly needs to be in the Capitol, and let's be as safe as we can and take committee action as well while we're in the Capitol. Representative Heiberger.
Mr. Chair, would you entertain one last bill introduction? I had stepped out.
Natalie, you're still down there? Yep, Natalie's looking at us, so we will certainly do that. Representative Heiberger.
The bill draft number is 21 RS 0184. It relates to name changes in divorce actions, and I'm requesting it on behalf of Judge Sally Pokorny of the Douglas County District Court. And if you need the spelling on that, just email me, Natalie.
Okay. Did you get it, Natalie? Yes, perfect. Okay. Any questions? Any objection? If not, that will be introduced. Thanks, Boog. Anybody have anything else? If not, hopefully we'll see you tomorrow. Have a great evening. We are adjourned. Thanks, those of you on WebEx.